A heartiest good evening, everyone. Today, on the occasion of World IP Day, we IIPTs have organized an event. Let me introduce about what is World IP Day and its significance. So, World Intellectual Property Day is observed annually on 26 April. The event was established by the World Intellectual Property Organization, also known as WIPO, in 2002 to raise awareness of how patents, copyrights, trademarks, and designs impact on daily life and to celebrate creativity and the contribution made by creators and innovators to the development of societies across the globe. 26 April was chosen as the date for World Intellectual Property Day because it coincides with the date on which the convention establishing the World Intellectual Property Organization entered into force in 1970. The theme of World Intellectual Property Day 2022 is IP and Youth Innovating for a Better Future. Across the globe, young people are stepping up to the innovation challenges, using their energy and ingenuity, curiosity, and creativity to steer a course towards a better future. Innovative, energetic, and creative minds are helping to drive the changes we need to move to a more sustainable future. Discover how intellectual property rights can support the youth of tomorrow to create a better future. The youth of today are an incredible and largely untapped source of ingenuity and creativity. Their fresh perspectives, energy, curiosity, and can-do attitude, not to mention their hunger for a better future, are already reshaping approaches and driving action for innovation and change. World Intellectual Property Day 2022 is an opportunity for young people to find out how IP rights can support their goals, help transform their ideas into reality, generate income, create jobs, and make a positive impact on the world around them. With IP rights, young people have access to some of the key tools they need to advance their ambitions. I would like to introduce Mrs. Chesha Sharma, Director of Indian Institute of Patents and Trademarks, which is IIPTA. So she is an entrepreneur in the intellectual property IP industry with 13 years of experience and knowledge, and also a patent agent registered under Indian Patent Office. She has an educational background with graduation in BTech in biotechnology and Bachelor's of Law, which is LLB. I would personally comment this is a marvelous combination to enter inside the IP industry. I would like to welcome our first guest speaker, Mrs. Jessica Zimberlin Eastman. So I would like to introduce about her. She assists clients in a wide range of technical fields, including chemistry, nanotechnology, chemical engineering, and mechanical engineering, with a primary focus on polymer and material science ranging from monomer synthesis through product development. She has completed her education in Doctor of Law from UNH Franklin Pierce School of Law and PhD in Polymer Science and Engineering from University of Massachusetts, Amherst, US. We welcome you, ma'am.
Hi, thank you so much for inviting me to join this great day. My name is Jessica Zimberlin Eastman. Thank you for the introduction. So let me just start sharing my screen. So just take a second. World IP Day. Okay. So I decided to focus a little bit on inventorship for my talk with you guys today, because inventorship in the United States is different. It's treated differently than it is around the world. And even in the United States, it can be something that is a little ambiguous, that people have trouble figuring out what it is. Are you an inventor or are you not an inventor? And it's really important because, as we'll see as I go through, it can affect your rights to the patent and then also ownership. Okay, so just a real quick thing about myself. A scientist / engineer at heart. I have a PhD in polymer science. I've been in and out of industry. And then, during my postdoc, sorry about that. During my postdoc, I went to a seminar on careers off the bench and just kind of fell in love with intellectual property and this idea of, being at the forefront of innovation and working with inventors to help protect their ideas. All right, so to be an inventor, you have to have an invention. So we'll take a quick moment to think about what an invention is, right? So an invention, you have to have conception, so you have to have an idea, and then you have to reduce it to practice. That means you actually have to make it. So, I'm not sure who's familiar with the movie, I know, but it was pretty big back in the 80s. It's called Back to the Future. And what they had here was this hoverboard. So they conceived of this idea of a skateboard that doesn't need wheels and just kind of hovers over the ground, and then you can go all around the town with it. So that's a great idea, but it's not an invention because it hasn't been reduced to practice. And unfortunately, all these years later, still not reduced to practice. So not an invention. So you have to have your idea and you have to be able to make it or do it. Okay, so once you have your invention, are you an inventor? So only those who contributed to the inventive concept, so helped actually come up with the idea and how to make it, are considered invention. So some key things, it's not just people who are carrying out instructions. So say you're in the lab, you're a lab tech, and the supervisor just says, go into the lab, run these 10 experiments and show me the results. That person who just merely ran the experiments and obtained the results won't be an inventor. On the flip side, on the other side, a manager who's just overseeing the lab or somebody who just posed the problem, they're also not going to be inventors. And then when we see, and we'll go through a hypothetical in a second, inventorship is really going to be based just on the claims. So it's what made it into the patent and what's claimed in it. And all of these decisions for inventorship must be made on good faith. And you also can't purposefully exclude people. So you can't say, well, you know, Ryan didn't really help out as much as I would have liked. We're going to choose to exclude him from inventorship. That is not how it works in the United States for inventorship. Okay, so why is this important? Inventorship is really important because one, if you get it wrong, you might have to make a correction. In the worst case scenario, it could completely invalidate the patent. It could result in some sort of other proceedings, and it could result in a finding of inequitable conduct, which nobody wants. And the moral of this story right here is it could be very expensive. It could result in some serious litigation. Okay, so inventorship versus ownership. So outside of validity, why it's also important is each inventor in the United States is the owner of the entire patent. So that means that if your name is on the patent, you have certain rights to that patent. Now, if you work in a company and you invent something, what you might have already done is assigned ownership to your company. You might have already told the company that because I'm working for you under your guidance, I'm actually going to give you ownership. But because you're an inventor, you will have those rights. Okay, and so inventorship here then is not the same as ownership. Just because you are an inventor, if you've already assigned your rights away, could mean that your company is the owner of it. And so most companies, as you probably know from just by virtue of employment, you've probably signed some sort of assignment agreement with them. Okay, so here's our hypothetical, and this is how we really suss out who's an inventor versus who's an owner. And I did it in terms of graduate students because I think this is a youth-focused event, right? So here we have a bunch of graduate students. They're together in the lab. They're standing at these desks. And they're getting very tired. And we're going to use a chair example because everyone around the world, right, knows what chairs are. And it's just a real simple way to understand what we're talking about, these more difficult concepts. So we have a group of graduate students. They're very tired. They want to sit down. They have nothing to sit on. So they come up with this idea of a chair. Okay. They're also patent savvy. Kudos to them. And they have a chair. So they have this claim one, they have a surface and it's located a couple feet above the ground or, you know, somewhere in the meter range for the rest of the world, right? And then also they decided, okay, this surface has to be supported by 1 to 5 legs. So they come up with this idea. So now we look at inventors. Those are so the students, right? They came up with the surface and the legs coming down. So for by virtue of claims 1 and 2, these students are inventors. Now, because we're going to assume that the students have assigned their rights to the university, that means that the university is going to be an owner of this patent. Now, the advisor who is merely advising them, who wasn't in the room at the time, who didn't help them come up with this idea, who really had nothing to do with it, is not going to be an inventor in this case. So the advisor is not an inventor. And so there's no ownership rights by virtue of the advisor. Okay, so now what happens? happens? The graduate students are so excited about their invention, they run to the advisor's office, they tell the advisor all about it, and the advisor thinks about their bad back, and they say, what would really be nice is if we put a back to this chair for people to rest back on. Okay, so now we look at the claims and we say, okay, here's our patent, here's our claims. So we have a chair, but it's now going to further comprise a back. Okay, so what does this do for inventorship and ownership? Well, now because we have claim 3, the advisor is also going to be an inventor. And because we're going to assume that the advisor has some sort of agreement with the university is also going to be the owner here. Okay, here's where it gets tricky. So the advisor now goes to some conference about furniture, and the advisor is so excited about this chair that they talk to an industry colleague. Now, the industry colleague is not associated with the university at all. And together, over drinks, they come up with this idea of a hanging chair. It doesn't have to be supported from the bottom. Maybe it's going to be supported from the top. Okay, so what happens to the claims? Now we have claim 4. So we have wherein the surface is supported by an upper chain. Okay, so we look at inventorship versus ownership. So now we have the students and the advisor. The advisor is now an inventor based on claims 3 and 4, but now the industry colleague is also an inventor based on claim 4. So what happens? So, say the industry colleague works at a table company. He's been making tables for years. Now he's an inventor on this application. He probably has some sort of rights by virtue that have been assigned up to the company, and the company owns this. So now the company can start making these chairs, and there's nothing the university can do because the company is an owner of the whole patent as well. They're both equally owners to the whole patent just by virtue of this claim 4 and the inventor from the industry colleague. So as you can see here, it's really, really important to know who the inventors are because you get certain rights based on this. And this especially this part right here really illustrates why it's so important that if you have somebody who's not part of your organization, who's not part of a university, and you start talking with them about your inventions, you could be losing or giving up some ownership rights to this person who could be a co-inventor. Okay, so key takeaways, just to kind of sum it up. Inventorship, we can see, is not the same as ownership. And in the United States, each inventor is going to be an owner of the entire patent. So that really affects your rights if you have an inventor on. An incorrect inventorship, keeping somebody off of an inventor or adding somebody on who's not, could potentially invalidate a patent. There are ways to correct it, but it could be very expensive. And if it's not done in good faith, again, you could lose rights. And then inventorship is this claim by claim determination. If you are an inventor of one claim, you're an inventor of the whole patent. So practice tips, really take the time during drafting an application to determine who's an inventor, and make sure you have it right going in. And then consider any discussions of inventions that you have with individuals outside of your organization before you have them, because you could accidentally give up rights to your patent. So with that, thank you so much. I think that's right at about exactly 10 minutes.
Awesome, Jessica. I love this case study personally because this was so simple and you were able to give your message. So one question I want to ask on behalf of the audience, like practicing in the US, like what is your greatest challenges while working with different types of clients? Because sometimes like clients don't understand the importance, as you have illustrated in your case study, about the ownership or inventorship. So what are your greatest challenges at your work?
Yeah, so some of the greatest challenges are, when you have an invention come in with a whole bunch of inventors, usually inventions might have 2 or 3, but then you really have to sit down and say, well, okay, we have to remember that we can't just give out inventorship. It's not just a right by virtue of somebody working in the lab. You really have to think about this on a claim by claim basis. So to take the time and break up each claim and say, well, who did this and who did that? And the inventors have to really think, well, who was in that meeting and who said what? And that can be very difficult. So we try to remind, especially when we give presentations about inventorship, as you're having these discussions, write down who said what, really think about, who the invention, where it came from. And that, even So as the claims get modified through prosecution, some claims might be dropped, some claims might be added, and that can change inventorship too. And that's a really important thing to keep in mind as you go through. So it's keeping inventorship in mind. The whole process is also a challenge.
Awesome, awesome. Zish, ma'am, do you have any special comments to Jessica's presentation?
Yes, I would love to ask, what do you think is the best part of your role?
Oh, the best part of my role is seeing all the different technologies that come in. So I work with university folks. You get real technical, down to the chemistry and really understanding why it's there. And then, with really big companies where how they're using it, what they're doing, how they're taking this plastic and making it into a windshield. That's the sort of stuff I just really love, and kind of being there to see it all in so many different ways.
Awesome. Thank you, Jessica. It was great having you. And it was like awesome 10 minutes by the clock. Thank you so much for joining in, and we wish you a happy World Intellectual Property Day.
No problem. Thank you so much.
Thank you.
Yeah, so our next speaker is Mrs. Cheshta Sharma, ma'am.
All right. Thank you, Sija, for having me. So I want to have a very quick presentation. Just I'll not take more than 5 minutes because I know like a lot of speakers are in the lineup. So I want to share some Indian perspective which has come up like recently, and what things India is doing in terms of intellectual property. So a quick snapshot of the recent report which has come up from the Indian Patent Office, that at Indian Patent Office, first time in 11 years, we were able to surpass that there were more domestic patents were filed than the international patent. So this was like first time in 11 years. So this is a major thing going on inside the innovation culture, which is growing inside in India. Being a developing country, we are still developing. So this time domestic applications were higher, and there was increase in patent filing as compared to like last year. And India is growing in the Global Innovation Index. And most importantly, because Indian Patent Office has increased its efficiency. So there were 5x increase in the number of patents that were granted. So with all the professionals, this is a great news for us, because sometimes it was taking long years. Now we are able to expedite everything, publication, examination, especially for the startup culture, and we are able to get patents granted in lesser time. So it's a great news for professional like us, where we are spending more time on like long prosecutions and waiting for our like FERs to come. And all this has been that India is growing, and there's a great growth history of India, both in the private sector, and there has been record investments, which has increased to 19.2 lakh CR in this year, in financial year 2022 as compared to financial year 2020. So all these factors where investments are increasing, where private sector is increasing, where manufacturing sector is increasing. So all these upward trend is a good growth story for India. Why? Because when all the industry is growing, so we can expect more number of patents filing, we can expect more number of trademarks filing inside our country. So we are very proud of that. And because today's theme is like for the inventors, so with Make in India campaign, our government is launching a lot of schemes which is giving a lot of incentives to domestic manufacturing in all the sectors of mobile, electronics, automobile, pharmaceutical, drugs, API. So there has been a lot of investment being made under Make in India campaign, which will definitely lead to increase in more innovation and patent filing in this year. And with more and more companies registering, these are the factors, these are the trigger factors which I see that will increase all the IPRs, increasing not only filing, a respect for IPR, technology transfer, collaboration of technology between different industries. And we have highest ever like startup registration happening in the states of India, from Maharashtra, Uttar Pradesh, Delhi, Karnataka, and Tamil Nadu. And finally, startups is the culture in India, where they're like one in four, and especially fintech startup is growing, where 1 in 4 startups belong in India are fintechs, and we are expecting 20 unicorns going up. So it is going to be not only for the Indian professionals who are into patent or IPR sector, but also all these companies are looking for international filings in multiple countries. So we together as a fraternity, when innovation is going upside and is going up, and all the companies and the investment is going up, so definitely this sees an upward trend in all the patent filing. And finally, India has remained the hottest destination for mergers and acquisition this year. So I wanted to bring on all these pointers despite we are still in lower number of patent filing as compared to other countries around the world. But I just wanted to share this India's growth story this year, that we are very excited here in India as a country, because we are seeing more filing work, more registration work, not only increasing in India, but I get clients in India who are looking for PCT application and filing in like a major like 10 jurisdiction in Europe, US, Australia, New Zealand. So I'm very elated to share all these statistics with all my colleagues and all my speakers here today, because my aim of bringing here all the speakers from different countries was that to get a unification, that we can be united where as far as IP is concerned. So I'm looking forward for all the collaboration from my community in the upcoming years. Thank you. This is all. I'll just take 5 minutes. Thank you, Sija. You can move on to the next speaker.
Okay. Our next speaker is Gabriel Marcuso Cavalheiro. So presently, he's an adjunct professor at Universidade Federal Fluminense, which is UFF, Ethereum, Rio de Janeiro, which is in Brazil. He's a patent examiner at Brazilian Patent Office, which is IIPTA. He has received education from respective organizations, mainly World Intellectual Property Organization, Academy, European Patent Office, which is EPO, and Korean Intellectual Office, which is KIPO. Also, he is having a technical degree in economics from CEFIC or RJ Brazil. We welcome you, sir.
Thank you very much, Sheza, for this introduction. It's really a pleasure to be here to join the session on World IP Day. It's a fantastic day to reflect about the importance of IP, especially this year for the youth, for the young generation. So innovation has a very strong link with intellectual property. This link is becoming more and more strong as time goes by. And the window of opportunity is very good here, but a short one. So I think it's interesting to share with you a very new topic regarding IP. I'll share part of my research. So I recently published a paper on Bitcoin, on how patents are being filed addressing Bitcoin technologies. And I'll share some insights of this paper, which was published by the Journal of World Intellectual Property in February this year. So it's really a fresh research. So let me share my screen with you. Let's hope I get, let's hope we get on time here. I hope everybody's seeing my screen. So I just showed my paper and share. Visible. Oh, cool. So thank you, Shesta. So I just share my insights. I conduct research. My research group actually focused on analyzing IP data, not only patents, but also trademarks, industrial designs, also copyrights. But this research we focused on patents addressing Bitcoin. So Bitcoin is known everywhere nowadays. It was not like that maybe 5 years ago. It's a new cryptocurrency. It was launched actually in October 2009. So it has a bit more than 10 years, but it experienced explosive market capitalization growth. So that's why everybody talks about Bitcoin. Here in Brazil, it's really a big trend and it's growing fast. So it kind of motivated us to take a look at patents addressing Bitcoin. So we published this research. I hope you can see later. Regarding the patent applications, we saw also an explosive growth. If we take a look here in 2009, we see that the patent applications really exploded. There was a huge growth starting from 2016. And what's interesting about that is because it follows Bitcoin market capitalization. So in the very beginning of Bitcoin, one Bitcoin used to have a valuation of cents of dollars. Nowadays, it's about $40,000. There's a lot of volatility. The peak value was November last year. It was above $60,000. And what we see is that the value chain regarding cryptocurrencies, they are also influenced by market capitalization, because it follows the market capitalization, the value of Bitcoin, with a very strong correlation here. And in the beginning, like, as I said, Bitcoin was launched in 2009. There were less than 10 patents per year until 2016. And then if we take a look at Bitcoin valuation, 2016 and 17, there was a peak. A lot of people were talking about Bitcoin bubble, but the value actually dropped after the beginning of first quarter of 2017. But after the start of the pandemic in March 2020, the price skyrocketed. If we take a look at the patents, they really increased, like from less than 10 a year for more than 140 in the year of 2018. We see a reduction in the number, but this is because a lot of actually patent offices, they delay the publication of the application. So you only know that the patent was filed like 2 years after that. So that explains this drop. It's not a reduced interest in Bitcoin, but rather actually because the documents were not published yet. Taking a look at the countries, we see a rivalry between the US and China. US leading just with a few documents as compared to China. The other countries going way behind. South Korea in third place, Great Britain in fourth, Japan fifth. The other countries, they don't have a lot of patent applications. So it's really a lot of firms interested. If we take a look at the types of applicants, it's also worthwhile to mention above here in the graph. We see that most applicants, they are enterprises. However, they are like 17% filled by education and research, universities, research institutions. Regarding the enterprises, they are feeling we don't see a lot of big corporations. Most of them, they are startups, probably most of them from young entrepreneurs. So it's really a very hot topic. So we consider Bitcoin nowadays a technological hotspot. In terms of the most active areas, it's interesting because the patent data reveals a lot. So we have IPC codes revealing what are the most interesting areas for applicants. So we have the IPC subclass G06Q, so indicating that data processing rather than hardware development is more like the focus of industry. So it really is interesting to take a look at patent data. So we can gather some very interesting insights, some technological trends just based on analyzing patent data. And just to finish this presentation, we are conducting also a research on Ethereum. Ethereum is the second most important blockchain, the second most important cryptocurrency. And nowadays, there are even more patent applications concerning Ethereum as compared to Bitcoin. And so we can advance that to you. We haven't published this research yet. It's submitted, but not published, but we can share with you. It's very interesting forum here. And so Ethereum is launching a 2.0 version, which has some improvements regarding some limitations of Bitcoin. So there are a lot of patent filing activities going on regarding cryptocurrencies, and Ethereum is leading. Bitcoin is also attracting a lot of patent applications. All right, thank you very much for this opportunity. Nice to share this research with you. So
thank you, Gabriel. It was like awesome paper. Maybe you can share up a link with our audience in the chat. Maybe they would like to read your research and get some insights from
sure.
Your findings. So, so just one question. So when you do such kind of research upon the patent data, what are the greatest challenges that come to you as when you are analyzing all these patent trends?
Well, great question. There are a lot of data regarding the patent application. So you really need to choose one focus. And in terms of academic research, we really need to find the most important research gap. What is most relevant to take a look, and because the document is so rich, you have really different angles that you can look at. So I think the most challenging part is really finding the right research question and try to identify a relevant pattern, from this data. And what's interesting that we can share from another area, we can actually bring these insights to other areas is that this is a pattern that we analyze for Bitcoin, for cryptocurrencies, but this is really a consistent pattern for technological hotspots. So industry, if there is financial, economic interest regarding a technology, there will be a strong, there will be a lot of registration. There will be a very strong and visible footprint of IP data. So the questions are there. So let's go and examine the IP data. It's really rich. As I said, I don't research only patent data, but trademark data is very interesting. You can look at internationalization patterns as we do in our research group. You can do identify strategy. You can couple with financial data. It's very interesting we had here because there is in a lot of cases a very strong correlation between financial data and IP data. So the possibilities are really there are a lot of possibilities in that regard. And since I'm from Brazil, it's a developing country. I think we really need to catch up. So it's just like somebody said about India before. Just Brazil is the same. We have a lot to catch up here, and IP knowledge also needs to be shared in the country. It's really critical to the development of the country to increase prosperity and have a positive effect on society.
Absolutely, absolutely. Over to you, Zish, ma'am, if you have like some questions, some comments.
Sure, I wanted to ask you. So, so typically in the IP industry, evaluations are very hard to do, especially for patents. Do you think Bitcoin and cryptocurrencies or the blockchain method could be used to help validate those the valuations that you give to things like patents?
Yeah, I think it provides a lot of it provides a reference because there are more than 20,000 cryptocurrencies nowadays, but most of them they are irrelevant if we take a look at both market capitalization and trading volume. Mm-hmm. And so if you have a patent concerning a very small cryptocurrency, we can estimate that the value of the patent is likely to be lower as compared to a Bitcoin patent or Ethereum patent, especially those that are really applied in existing services. And I think the valuation, it really has an impact. The market capitalization of cryptocurrency certainly has an impact on the value of the patents. That's why a lot of firms, they opted to start patenting a lot Bitcoin and Ethereum technologies, because they really believe that there will be somebody paying for that. They wanna dominate the market.
All right.
Right. Thank you.
Thank you. Awesome. And it was great having you, Gabriel, with us. And thank you. And happy World Intellectual Property Day from entire community to you.
Oh, thank you very much. Glad to be here. It was a pleasure.
Thank you. Over to you, Sija.
Yeah, our next speaker is Rosanna Libatsi. She is a lawyer by her profession who is passionate about international economic law and policy, particularly the law of intellectual property. She is currently the IP or commercialization policy expert at Qatar Research Development and Innovation Council. She has completed her degree in Masters of Law in International Economic Law from the University of Warwick, England. We welcome Bilal.
You have to unmute yourself.
I said a whole paragraph without realizing that I was actually on mute. Sorry about that. So I was talking about this year's theme and why it's so important that we have to talk about how to unlock the potential of the youth when it comes to IP. So in my opinion, arguably, the youth represent the most entrepreneurial, imaginative type of human beings these days, because they are growing in this digital age. They are born in this digital age. They create IP because of fresh perspectives, because of their curiosity. They need to change the future. And because of that, it's very important to put emphasis on how IP can actually help these youth to develop more IP assets for the world to use. And also as consumers of IP, I think the youth, because the population is mainly the youth in many countries, especially developing countries, it's very important for the youth to really understand what is it that they can do to protect their assets, and what is it that they can do to make sure that they're not infringing on people's intellectual property. So one thing that comes to my mind right now, which is one of the key challenges, is intellectual property awareness. Sometimes we take this for granted because we are often in the field, we are working with IP, we assume that this is something that is easily consumed or understood by people. But IP, as you know, is a very abstract area. Unless you've gone through it, you can have no idea about it. In Qatar, I work with researchers who apply for research funding. We see they are failing to articulate clearly the outcomes of their research in terms of intellectual assets that is going to come out. What more the youth who are still growing and yet to understand what this really means. So for me, as a lobbyist for IP, as an IP expert, as someone who wants to be part of a system that facilitates IP knowledge and understanding, because everyone has said up to now is concerning the core of intellectual property, patents and specializations in terms of blockchain. But sometimes the fundamentals of what is IP can be missed out. So for me, I really want us to look into how we can push curriculum change within our countries to make sure that it is embedded in the curriculum. I don't know in India or in the US or Brazil how it's like, but here in Qatar, it is not yet there in the curriculum to teach intellectual property. We have signed agreements with WIPO to provide training to graduate students and undergraduate students in law. But we know the creators are not going to be coming from law. They'll be coming from the engineering departments, they'll be coming from the biological sciences. We need to make sure that this training and modules are also happening in these institutions, in these fields, if we are able to realize a group of people, the youth, that understand IP, not only being aware, but to understand the different parts of IP, understand how when they are creative and entrepreneurial, they create something fantastic, how they cannot share through signing documents like disclosure agreements, filing for provisional applications quickly and stuff like that. So I think it's very important. I wanted to emphasize this, that it's key to come down to the fundamentals, to the basics, that let us empower the youth to have a clear understanding of what IP is, a clear appreciation of not infringing on other people's IP. In that way, we are really going to develop a group of people that understand IP. As already mentioned, I myself, I'm in Qatar, but I come from Malawi. It's an African country. We know that people leave countries, like most countries, we leave to look for greener pastures. There's a lot of brain drain because of lack of maybe development in the countries. This can change if people can know that having intellect, having the creations of your mind, the IP, can actually transform a country. And if we can start now, who knows how this can really help the future in 10, 20 years within our countries. So I just wanted to share that piece. I did not prepare any presentation. I just wanted to share you my insights when it comes to how I see the challenge right now in the world when it comes to IP. If you have any questions, please feel free to let me know.
Sure. Thank you, Rosanna. It was a great insight, because we on World Intellectual Property Day, we are trying to understand the IP perspective, which are different in different countries and according to their ecosystem and economic system. So what do you think will be the next year promising in your jurisdiction, or how it is going to be there? Maybe increasing more awareness, or what are the challenges that you think will be overcome by next year?
So, as you know, as you've heard, I work for the Qatar State Women Innovation Council. We are trying to facilitate innovation within the ecosystem. We have a strategy. We have identified what are the key issues that we need to tackle. For example, we do not have a national IP policy or national IP strategy. So that is number one on the agenda of the government. We are working directly with the ministry responsible for intellectual property to make sure that we have this national agenda, national strategy for intellectual property, within which we're going to have different initiatives, one of which is intellectual awareness, IP training, as well as giving incentives to, let's say, SMEs to be able to protect their IP, because we know SMEs lack the money, the finances to do that. So we are really looking at connecting the dots of where the challenges are in the country and making recommendations to the relevant ministries to make sure that they enforce this and make it a law. And hopefully, because in Qatar, IP is really in its infancy stage, we have built infrastructure here. Education is strong in terms of the research community. We have some of the big universities from the branch campuses of the US or UK. They are also here. So we have created this critical mass of research. People are developing outcomes, but we see that when we look at the Global Innovation Index, Qatar is really on the lower side. This is showing that we're not really giving more outputs of research, even if we are creating research, but IP is not shown. So we want to connect the dots to see where is the problem. So I think moving forward, that's where we're going to be looking at, actually starting 2023.
That would be awesome. Over to Zish, ma'am. Any comments or anything you want to ask?
Sure. So you're completely right in saying that the innovation exists within engineers and scientists. So how do you actually ensure that they understand that they can protect their IP and can help innovate? Because anyone who is educated on IP is usually at a university level where the interest of the university doesn't align with a creator's interest, right? So how do you then promote those individuals to go on and create things?
So in Qatar, where I'm working, we do have policies that they incentivize researchers in terms of royalties. So they know that one of the things is if you do create IP and it's commercialized successfully, you're going to share in the royalties. That's one incentive to promote. We do workshops, a lot of workshops to help them understand the importance of IP. In terms of funding, we also put a requirement for IP, and through which we tell them that if your research has high IP potential, it's going to be funded. So because of that, they're really looking into understanding what is it that is required of them to do in order to actually come up with these IP assets. So every progress reporting, for instance, every 6 months they do progress reporting for their research. They have to show what IP assets they're developing. If they're not meeting those outcomes, we have midterm discussions with them to remind them. So it's an ongoing process that we're doing. At the end of the day, they are being recognized, maybe inventors of the year, innovators of the year. We do have these awards, which push them to understand. But when it comes to the youth, currently it's all about awareness, trainings, workshops. Yeah. Hope I've answered your question.
Yes. Thank you so much. It was awesome having you, and getting perspective from your end was it was great for all of our audience and community here. Thank you, Rosanna, and we wish you happy World Intellectual Property Day.
Thank you. Thank you.
Thank you. Over to you, Sija, ma'am.
Okay, so our next speaker is Gurveer Singh Sidhu. He's an intellectual property specialist at Own Innovation, which is in Canada. He's an internationally trained lawyer, computer science engineer in Kitchener, Ontario, Canada. He's also a patent agent. He has a demonstrated proficiency in patent drafting and prosecution and litigation at trial and appellate levels with over 100 court appearances. Having worked as a computer science engineer and later as a lawyer and patent agent in India, his practice profile covers drafting, prosecuting patent and trademark applications, providing patentability opinions, validity searches, infringement analysis, building claims charts, IP landscaping, and IP portfolio management. When we talk about his education, he has completed his part-time LLM in intellectual property rights from New York University Hall Law School. We welcome you, sir.
Thank you. Hello, everyone. I hope you can hear me well. So it's good morning. Okay, thank you.
Yeah, good morning.
Yeah, good morning from Canada. Very happy to be here, especially being part of a very brilliant panel. I'm sure that I'll be taking more from these insightful discussions rather than offering lessons from my humble experience. So yes, just a bit to add on my introduction. Yes, I was a patent agent and lawyer in India for a while. My first few years was spent at an open source advocacy organization where we prosecuted and filed patents for clients locally and internationally. So open source is an interesting domain within IP. It's about setting your boundaries, filing for patents, filing for trademarks and your copyright, but giving it to the public, right, to leverage or to introduce into their own inventions. The benefit of protecting them at the first place is to avoid any poaching by a third-party organization. There has been an consistent push against patent aggression, against large corporations pushing or aggressing their patent portfolio against sole inventors. So open source advocacy has been has been pushing back against that trend. Being a practitioner, of course, totally neutral, every organization has its own priorities. But yes, a couple of years back, I moved to Canada, attended the master's course with focus on IP, and it's been nearly 2 years that I have been as an IP specialist. With focus on this year's theme, how I look at it is recognizing the contributions that youth make to the innovation, and then empowering them with tools to protect their innovation and creation. So it's a more longitudinal sort of support rather than focusing on just one group. It's like creating a generation of innovators and creators who know how to protect and commercialize their inventions throughout. I'd like to share some of the best practices that I have come across, be it India or in Canada. One that stays at the top is the IP Clinic program that I have seen as being more active within the Canadian law schools. There's one that I'm part of, and I'd like to share my screen. Please let me know when you can see that.
Yeah, we can see that now.
So can you see the IPOs good on the screen?
Yes, we can see that.
All right. So I'm part of, I'm a clinic fellow at this IP clinic in our law school, and it provides a variety of services. Any inventor with humble means can, of course, approach the clinic, and the clinic has lawyers, patent agents, and also students from the law school and the university to assist in that transaction. So it's highly subsidized. One of the most common criticisms of IP is that the services are very expensive when sought from IP firms. So IP clinics are a good spot to fill that gap. They can assist the inventors in getting that quality IP services, be it patent filing, be it patent searching, trademark searching, and also good strategic advice, because most of the IP clinics in Canadian law schools have lawyers who volunteer their time in offering their services. I've seen this, call that a case study, to be very effective. The inventors, the creators are looking for services, being copyright, trademark, patents, are highly satisfied, and they have had their time going through law firms, spending so much money. But this provides services of comparable quality while not burning your bank. So the common services that we work on is running patentability searches. So before you get a patent, before you can, the government allows you a patent, there must not be anything similar that has already been filed or already been disclosed in the public. So it's sort of the first test for your idea, for your invention, before you delve into spending so much money to file that patent application. These patentability searches run from anything $1,000 to $2,000 in Canadian law firms. So here they are provided at no cost, a $50 administrative fee. So I have personally seen that to work really well, and I hope other governments could. I'm aware that law schools and even universities have IP centers, but they should work, I guess, on the outreach and also involving lawyers who continuously volunteer their time and bring in like clients and offer services in a more sort of professional standard. In addition to helping their inventors, these clinics work as a good forum to train students of the universities, because these clinics also have students who work with the lawyers in assisting them with the services, and they get guidance from the lawyers. They are part of those inventor interviews. So they help filling that IP awareness gap for the youth. And I believe that university or the college, that's the best forum to equip the students or the youth with the tools that they need, especially on the IP front. Secondly, yes, Canadian government has been investing continuously at these clinics, at these university-led programs. So, so some intervention or some support from the governments is necessary to help address that gap, because it's in strategic interest that the IP that is generated within the domestic boundaries of the country or by the inventors is not poached by the third parties, that it's protected by the inventors themselves. Canada is a developed country, but it still has its challenges in IP protection and commercialization. There has been significant research that domestic innovation was captured by international entities. There were third-party takeovers. One Canadian IP expert once said that Canada has become an open source for every foreign international IP takeover. So the government is aware of that. And since last few years, it has been seen a significant investment and push towards by the government, both at the provincial and the federal levels, in building IP framework development and targeted investment in certain technology areas, be it AI, be it automobile, health sector, and ensuring that this investment is translated into IP protection, that the patent filing, as the previous speaker said, that it translates into a number of patent applications being filed, or certain baselines are set to be met in those projects. Budgetary outlay, so last year, for the first time, the Canadian government invested $750 million in developing innovation clusters to promote innovation and also to make sure that it translates into IP. There's another thing that I would like to talk about, especially considering the theme that we have this year. In my career, it's common to hear unfortunate stories when contributions made by the youth as employees, as young employees, or as research students were not recognized. Could be example that a research student working at a university laboratory, and there was a patent that came out of the research when the student couldn't get their name on it, or they got their name and then it was assigned because that was part of the university's policy, right? There are different examples, there are different reasons why this could happen. Most generally, lack of awareness, that's common, it's too late when a student gets to know that. And there's naturally a power imbalance when you're researching under a professor or working as a young employee. There's some corrective steps that could be taken. The universities generally have IP policies, and so does many employers. So before getting involved in that research, I'd suggest that the youth or anyone who is part of that research reads through that IP sharing agreement quite well, and there's always a room of negotiation. So, and considering that time, there's something that I'd like to talk as well. It's about the imbalances in IP ownership. So there's definitely this intersectionality where, for example, research has found that there has been less IP ownership in women compared to men. There have been so many examples when indigenous and tribal traditional resources were poached by, sometimes internationally. It's very reassuring. I can see from the speakers and that there are a lot of women practitioners within IP. This is something that I've seen back in India and in Canada as well, compared to other practice areas of law. But I hope that's translated into IP ownership. There are interventions that are made by governments. Canadian government has been pushing to promote that the tribal and indigenous IP is protected and there is a collective IP ownership for them. I believe that the Indian government has given some discounts or subsidies on IP filing or prosecution when the inventor is a woman. So initiatives like these at the inception promotes creating that balance of IP ownership, which is very important. So with that, I'll in considering the time, I'll close and I'll open for any questions.
Thank you, Gurbir. It was a nice overview, and because you have experience in both the countries, India and Canada, so my first and the only out of curiosity question is that how do you compare as an IP practitioner the practice and the ecosystem in both these countries? And definitely you made a good point. Yes, in India we have incentive now that if a female is an inventor or one of the inventor, then there's a subsidy for the filing.
Right. So from a practitioner's point of view, I'd like to say that IP is one of those rare practice areas within law where your skills are highly transferable. There are international agreements that were filed decades back, which normalize standardized IP statutes. So yeah, standards of patent filings, trademark, and are quite similar. So I was able to carry forward my skill set. But from a more innovation sort of ecosystem, every country has its own challenges. What I have seen is that there are imbalances, be it internationally, be it domestically, and research has, and there have been so many publications around them. Like I said, imbalances in IP ownership among men and women, and also tribals and the indigenous peoples. But yes, there have been consistent efforts by the governments to correct that as well. So yes, there is a high level of comparability among the challenges, and also the skill set that you need to practice IP internationally.
Thank you, awesome. Over to Zish, ma'am. We can have one quick question before we move on to next speaker.
Sure. You earlier mentioned that Canada also has some of its own struggles, and I think we've all heard about how trademarks are relatively slow in Canada. What are some of the biggest challenges that you've seen?
In what regard? Could you please repeat your question?
Sure. In respect to some of the challenges that Canada specifically is facing, what do you think the country seems to focus with? Have any issues with in terms of IP, relating to IP?
Right. Since you mentioned trademarks, I shouldn't be saying that, but there has been some delay from the IP office in getting the trademark applications prosecuted. So there's a huge delay, and with some time, because of course you have common law rights to your trademark unless you get one registered, but it's taking a lot of time. So last I heard is it's taking almost 2 years to get your first office action once you have filed a trademark application. So yes, I think there is a room for improvement within the IP office to hire more examiners and to make sure, because for US, of course, it's a lot more timely that you hear from once you have filed your application, be it an office action or if it's a courtesy letter, but it's taking time to get things processed here. So yeah, maybe some room of improvement there.
Yeah, thank you, Mr. Gurbir. It was nice having you, and from the whole community, we wish you happy World Intellectual Property Day.
Thank you so much. You as well.
Thank you. Over to you, Stija ma'am, for our next speaker.
Okay, so our next speaker is Wissam El Emel. He is presently an intellectual property legal expert in the IPP office, or IP registration, enforcement, and also a professor at Université Saint Joseph de Beirut, Lebanese University. He was a lecturer in intellectual property and Procedures at Lebanese University. He also worked as a legal expert at Ministry of Economy and Trade. When we discuss about his education, he has done a degree in Masters of Law, which is LLM in Intellectual Property Rights from the International University School of Turin, which is in Italy. We welcome you, sir.
Hello.
Hello, sir. We welcome you for your session.
Thank you. Thank you, everybody. Thank you for the introduction. Actually, yes, I'm working as an IP expert or specialist in Lebanon. And since many years, I'm working or acting at the head of the Lebanese IP office, which gave me a very big chance and opportunities to know and the intellectual property situation in Lebanon better. Of course, in addition to my hobby, which is teaching or delivering lecture in IP in many Lebanese university, actually, as we have many private universities, and Lebanon is a well-known country in this field. I will start saying that the situation in my country since 2019 is very critical due to the political situation, of course, the COVID-19 situation as well. And unfortunately, after the biggest explosion, which named by Beirut explosion in August 4th, 2020. It was really a disaster. And after we have a very critical situation, fiscal and monetary situation, the Lebanese currency lost maybe 90% of its value. This is negative side, but to turn on the positive side, the number of IPRs registration increased for Lebanese, and our office is dealing with industrial property and copyright registration. I mean patent, trademark, industrial design, and copyright and related right. We have a big increase. Before, the most of the registration was made for foreigners. After 2020, the Lebanese registration is getting huge. We have a huge number, despite the situation that the country is facing. And of course, we should take into consideration that Lebanon is not member yet of neither of PCT or Madrid Protocol. We have sent request for the Lebanese parliament to allow the Lebanese government to adhere to both treaties, but still we didn't have the approval yet. The registration fees is very cheap for now because of the Lebanese currencies lost 90% of its value, which means that you can register a trademark on one class or a patent in Lebanon for 30 or 35 US dollars. It is for the situation for the moment. As the Lebanese are known as survivors, and as we have a very active Lebanese youth, and they are dealing more and more with intellectual property, and mainly with the food industry, food and beverages industry. Maybe many of you, they did try Lebanese food in somewhere, in everywhere actually. Every country you can find the Lebanese restaurant. This is our identity, and this is the main problem that Lebanese government is facing abroad. because our restaurants is getting a good business, I mean franchise business. We are facing many problems abroad. However, we are at the IP office, we are trying to be more effective to turn our office for a modern IP office. Our focus, actually my focus is on the automation side, to offer more services, online services. Of course, we are facing many problems, but in the same time, as the Lebanese Ngos, as mentioned, are the most important asset, as they are trying to find a solution for the crisis that our country is facing, and as they are expecting from us to support them mainly in trademark and patent registration, we are doing our best to adhere to joint PCT and Madrid protocol. One of the experience that I will share with you today is the working with some Lebanese NGOs, and these NGOs are dealing with Lebanese people from different places in Lebanon. As we had a project with the Swiss government about geographical indication in Lebanon, and we recognize that we have a very good items, examples, items, maybe agriculture, handmade, could be protected as geographical indications. And now, of course, we have a draft law which is pending at the parliament as well. We were working with these NGOs in the agriculture, in the food industry. One of the program was headed by a well-known incubator which called BerryTag. This program was developed by BerryTag and co-funded by the Kingdom of Netherlands to support youth and startups turning agri-food challenges into solution in the MENA region, not just in Lebanon. This is what all I have to say.
Thank you. It is awesome that we are understanding what you as country and as an IP office in your country, the challenges you're facing, and how you're trying to automate and bring the modern services to the patent office. Thank you so much for giving such an insight, and I understand about the internet connectivity issues. So thank you so much. Still, you were able to join and give us your views. Thank you so much. I will introduce our next speaker, Mr. Bilal from Bangladesh Patent Office. So over to you, sir.
Am I audible?
Yes, you are audible.
Okay, yeah. Good evening and happy World IP Day to you all. Thank you, Chesta and IIPTA for the invitation in this event. Actually, I'm really honored to be a part of this program. I'm listening to you all, your thoughts on these occasions. I have a short PPT. I want to share my screen.
Yeah, sure, sir.
Is it visible now to you?
Yes, it is visible.
Actually, like other LDC, Bangladesh is truly speaking, Bangladesh is lagging behind for innovation and also the patent applications. So I want to share my thoughts on our IP systems in Bangladesh. As you mentioned earlier, that I am working in the IP office last 9 years. Very recently, I have completed my master's on intellectual property and development policy from KDI School, South Korea. So Bangladesh IP office is working to protect intellectual property rights, especially which office I'm working is the Department of Patent Design and Trademarks. This office is working on patent granting, trademarks registration, geographical indication registration, and also industrial design registrations. So I want to share my a few thoughts on our IP administration, our history of our IP administration, and about our IP offices and our national legal framework, and as well as we are the part of some international treaties. And some laws, I think, yet to be placed in Bangladesh, and also we have to party to be some international treaties also. And you all know that we are very glad to share that in this month our new patent law has been passed, and it was like 100 years back, like 1911. So after many years, it has been amended. And we have some initiatives from my government sides, especially for young innovators, because this year our World IP Day theme is IP and youth, innovating for a better future. And history is like our countries emerged as an independent countries in 1971, although the history of IP in Bangladesh is early 19th century, like in British regime, like our Indian subcontinent. And like most other LDC, the Bangladesh is unable to like use their IP resources to build, unable to like use IP resources into for IP capacities. Bangladesh is also member of WIPO, WTO, and also the signatory of TRIPS. And we have two IP offices, like one is Department of Patent Design and Trademarks, which is started its journey back in 2003. And another one is Bangladesh Copyright Office, which was actually established under the Ministry of Culture in 1967. And the IP office before 2003, there is two separate IP office, like Patent Office and Design Office of the Ministry of Industries, and another one is Trademarks Office. And I mentioned earlier, this is the two IP offices. One is Department of Patent Design and Trademarks under the Ministry of Industries, and another one is Copyright Office under the Ministry of Culture. And this is our national IP legislations, legal framework, Bangladesh Patent Act 2022. This is a very new patent act. And we have another draft Bangladesh Industrial Design Act 2022. It will very soon, it will be placed in Parliament. And we have Trademarks Act 2009, which is amended in 2015. And we have also Geographical Indication of Goods Production and Registration Act 2013, and Copyright Act 2000, and also Plant Variety Protection Act 2019. And we have concurrent rules like Trademark Rules 2015, Patent and Design Rules 1933, which was like 100 years old, and GI Rules 2015, Copyright Rules 2006, and Intellectual Property Enforcement and Import and Export Rules 2019. And apart from this, we have two policies like National Innovation and Intellectual Property Policy 2018, and also Industrial Policy 2016. And Bangladesh is a party of international treaties like International Legal Arena. We are the member of, we are the parties of WIPO Convention, also the signatory of Paris Convention, as well as TRIPS and Bern Conventions. And laws yet to be placed in Bangladesh. There are some laws I think we should be introduced in near future. Those are the Layout, Design and Integrated Circuits Act, Trade Secrets Act, and Act on Protection of Folklore and Traditional Knowledge, and also the traditional cultural expressions. And international treaties, there are so many international treaties regarding intellectual property issues, but we are considering especially now Patent Cooperation Treaty. It's already approved by our cabinet, and maybe by this year we are going to join PCT. And another one is Madrid Agreement for Trademarks. We are also considering this treaty, as well as maybe this year also we are planning to join this Madrid Agreement. And till now we have not planned to about Hague Agreement and also the Lisbon Agreement. And I want to briefly discuss about our new patent laws, the basic features. Actually, our old patent laws, I have already mentioned that it was a centennial old. So that's why it was not compatible or compliant with the TRIPS. So this law tried to be compliant, TRIPS compliance, and has inserted some provisions, new provisions, and some provision has been strengthened, like compulsory licensing provisions. And this new law inserted a provision like utility model and parallel importation. And also the term of protection, it was like maybe we are the country, like one country which term of protection was 16 years. It was not compliant with the TRIPS and other international arena. Now it's the term of protection is 20 years, like TRIPS and other international laws of the various countries. And this year we are inserted also the provision of PCT, because we are planning to join the PCT in this year. So we have a provision regarding PCT, and also the disclosure of the origin of the genetic resources. And we, the previous law, previous patent law, which was 1911, it has provision compulsory licensing, but this time we are trying to strengthen the provision, and we have inserted more requirements regarding compulsory licensing issues in our new law. And also in the previous one, there was no clear indication about the patentability criteria about the patent protection. But in this law, we specify specifically about the criteria of the patent protection and patentability criteria. And some government initiatives to encourage young innovators. Actually, I firstly mentioned that especially we are lagging behind the innovation, or also the innovation index. Our position is 116. So our government is trying to improve the situations, and as an IP office, we are working on it. And the special, actually the scenario of our country, like other LDC, may be the same. When we talk about like the intellectual property, or when we talk about the short term of IP, most of the people or most of the educated people also think about this is not intellectual property. They are maybe thought that this is like internet protocol. So awareness level is too much lagging behind. So we are working on it, and also we are working on mass level awareness among the stakeholders. So government has some initiatives in these years, like to the young innovators. There is access to innovation lab under the Prime Minister office. There is an innovation lab for the young researchers and young innovators, which is very much known as A2I lab for the young innovators for their research purpose. And government open innovation fund for the young innovators. And also this fund is distributed by the ICT Ministry, which is called ICT Innovation Fund, and government trying to collaboration among the industry and industry academia. So that's why maybe the R&D sector will be increased, and they will be efficient for the research and innovations. And we have also the Bangabandhu Innovation Grant Fund for the young innovators. And young innovators, those who are working in some research organization, government-led research organization, they have some incentive like promotion, and they have like some facilities for their innovations or their innovative works. And we are also encouraging our young entrepreneurs. We have young entrepreneurs, some programs, and also that we have startup and SMEs program. We are working on it. I think the scenario will be very soon will be changed, and we will be like, how can I say, to you all know that Bangladesh will be graduating by 2024, and for the taking the challenges and as well as the opportunity, we have to for sure to move forward our innovation, our innovative sector as well as patent sector. So thank you for your patience hearing. If you have any questions, you may ask. And thank you, Chesta and IIPTA for the invitation and sharing my listening my thoughts on IP issues of Bangladesh. Thank you.
Thank you, sir. And it was an awesome insight about the new patent law. And congratulations that your country has a new patent law which is compliant with TRIPS. So we are happy that you were able to share your insights with us. So just one quick question I have is that working inside a patent office in Bangladesh, what is the greatest challenge you are facing?
Yeah, I mentioned earlier that, the country like us, maybe the like other LDCs, the greatest challenge is the awareness regarding the intellectual property issues, because for like policymaker and also the educated people and also the government official, they don't know about the intellectual property issues more. So that's why when we are working on it, it's the greatest challenge for us to people to understand about what IPR is and why it is more important for us. And this is, I think, the greatest challenge for us.
All right, awesome. Any further question? Zish ma'am, do you have, or we can move to next? Okay. All right, Sija, we'll move on to our next speaker. Amy, I think, yes.
Our next speaker is Amy Nguyen. She is a paralegal with an expertise of 5 years in the domain of intellectual property rights. She has done a specialization certification in intellectual property law from University of Pennsylvania. We welcome you, ma'am.
Hello, can you hear me well?
Yeah, we can hear you now.
Hi.
Hi.
Hi, everybody. It's a pleasure to be here. Can I share the screen? I have a slideshow. Let's see if I can share this. Okay, shared it. All right, let's talk a little bit about me first. And unlike a lot of the intellectual property practitioner, I come from a third world country. I come from Vietnam, lived in Vietnam for 25 years. And then I grew up with counterfeit. So counterfeit is part of my childhood. At that part, I don't know if it was an infringement or neither. I understand that is a source of a violation in a trademark. And that I will question like, why women in my town is always my hat and bag with the letter LV in it? Can we put another letter on it? And then when I grow up, that question stuck with me. Go to the law school. And then that's how I step into IP. I would say myself, I call myself very lucky that I love IP dearly. Every day go to work was a happy day. I can see how the world moving because I deal with a lot of the invention. So as a current work, I do a lot of patent. As it's around 12 attorney, I help them with a patent range from industrial design, utility, blend, and the software patent. So all sorts of things in the patent. It helped me see how the world moving. And sometimes you can encounter some invention from the young innovator that you think it can be a breakthrough invention that change a human era. The era we are living related to metaverse or the 3D or hologram is really interesting. So let's share a little bit of the technical things today. In my first fellow, she already shared about the inventorship, share about the ownership, and share about the patent. So let's share a little bit of practical about what I do use day to day. I think it's very important to a young innovator, young patent agent, young attorney in the India. They know how to search for patent prior art in the US if they deem to work in the US, right? Let's see. Yeah, so this is how the system we use frequently. We will do, USPTO is a US patent, state patent, United States Patent and Trademark Office is the first system you should use. We always use the patent public search. If you see on the right of the screen, the FT is a patent searching. It means it's already searched only for the registered patent, granted patent, and the FT is for searching the pending application. So if you want to search for the application, you go for FT. For the patent, you go to for Part FT. The patent publisher, you can use this as well, but it will be not so fully informative like the other two. I think it will be very important for the young innovator, agent, or attorney first search for the patent before they drafting or before they consulting the client. When the client come with the first prototype, the idea, or even just a first draft of invention, you will have information in hand to consult them, right? That is the first one. The second ones we use is a Google pattern. Well, I mean, everybody maybe know about it. A lot of my colleagues in India know about it. They use Google pattern because Google pattern have a wider range. You can find Korea, Japan, Mexico, almost every country patent is here. Not all of them. For example, the other day I don't found some Chile patent, but well, every patent which is pending or maybe have a database on the WIPO, if it were intellectual property organization, you can find in the Google patent. The first one, the third one is a global dossier. This one is very local, but have a very large database that is linked with the EU IPO and also linked with the US PTO. So if you want to search, which just say your client want to file application in both EU and the US, go ahead, use global dossier. And of course, if you go up ahead for the PCT, you patent scope. Patent scope have a very modern function of searching. You just need to put a name or a title of the invention, or you just need to put a application number or publication number on the section, say front page. It will show you it will filter and show you the result that you want. The last one is free patent online. This is few people outside the USU, but sometimes I recommend it to fellow which come from other developing country because they can find source based on the section. So the next question for the young innovator, well, that is for the inventor as well, okay? For the young attorney and paralegal, where do you learn basic skill if you want to maybe step foot into the US market? You learn it from the United States Patent and Trademark Office first. They have a great learning thing. I leave the link here so all of the audience, they can access it. You can find from basic concept, they will explain about what is patent, what type of patent you're looking for, what is the step, how you maybe draft provisional application, how you filing petition, how you file application. All you need to file is here. Well, it's for a simple invention and you think you can find it yourself, or for young people, new people in the field, yes. But it's not for the lengthy, super technical patent, yeah? This is a EU IPO learning. I know that a lot of Indian patent agents who are excellent, excel themselves in the EU, they work and then they help us file patent application. Well, in my work, they help us file a patent application in all of the state of EU. And then the question will be, you are from India right now, and then you graduate from the program of the IIPTA, right? Well, just don't know it. And then you want to move from that to EU. You want to have extra skill. You go for EU IPO learning. We all know about Brexit. So we have a UK IPO where you have an online training tool. The UK, they decided a little bit more of slide and video thing, which I think for a visualizer type of study, they will like it. Not everybody like to study PDF, well, reading PDF. But while video study, you go for the UK IPO. If you want to solely practice in UK, since after Brexit, UK become a large market now. So well, aim for it. We talk about patent drafting. It is very essential skill for everybody. I'm sure with you, if you put that on your resume, you can draft patent and you tell your future employer, hey, I give you some sample of my patent draft. Look at it before you hire me. You like it, you call me. Then where do you learn the patent drafting skills? Well, WIPO have it. The training program go whole year long. So you guys just go and register for it. It's an essential skill, I say, for both US and for the UK. I'm sure people in the IP field all need to be a lot influent in English because of nowadays it's hard to find every law firm who not do any bit here and there in the international shade of color, right? We all do filing international PCT, we're filing in the US, we're filing in the EU. So I think it's very essential that you can know how to draft patent in English and also be excelled at it. It's a sellable skill. Huh? Oh, well, we talk about young innovator or we call young entrepreneur. Young entrepreneur nowadays divide into the millennial and Gen Z. Well, you're gonna see metaverse world, 3D world, everything will come from the young innovator. The invention is owned by young and younger people nowadays. Well, consider IP protection as the first step in your strategy, your startup strategy. We talk about trademark infringement. This case come into attention not too long ago. It's on 2022 April, as a guy goes to magazines that he shared the trademark idea with Elon Musk, and then Elon Musk go ahead and trademark it. Well, before you share any idea with other people, go do some IP protection on it. And then we will see that is a trademark infringement. We go back trade secret infringement. You know, all of the verdict with all of these millions of dollars just only come if you registered it. Okay, registered it. I repeat it. Young innovator, youth people, registered it before you do anything, before you go for the startup co-fund, before you go to introduce it in the networking, because it helps you to secure your idea. And we know that in the knowledge-driven economy nowadays, intangible asset is more valuable than valuable asset. It's worth many millions. And we have a patent infringement. Who don't know about Walmart? Walmart is sinking themselves in the infringement in the patent, and it come from the suit come from a lot of the family business and the startup learn from these case and then register your patent. Yeah, in the early age. Now, some of the colleagues of mine in the India were asked that the clients are not so sure, young innovators not so sure that they will expand themselves in the US, but they also do not want to lose their right in the US. Then I will tell them that they do not publish their invention even outside the country without taking any registration step. Unless you want to give your invention for free, everybody love it. Yeah, because we have a 1 year grace period. During that time, if you publish it, you need to register it. After 1 year, you already published, and 1 year from now, you still do not register it, but your invention, your idea become a public domain, and it's no longer eligible for patent protection in the US because it's already be considered a prior act. So if you are not sure about pursuing your patent registered in the US, but don't want to rule your right in the public domain in the US, file your provisional application. It's cheap, I tell you guys, so it's cheap. So file your provisional application. It provides you guys priority date. You have 1 year to file a non-provisional utility application from the provisional filing date. It gives you, young innovator, entrepreneur, even attorney, time to think about pursue it or not in the US. You don't know if your business will expand into the US, but it's sure it will be a safer way to secure your intellectual property. And well, have at some point need to point out here, the provisional patent application allow you to file without a formal patent claim, oath, or declaration. Well, such all other formality form, but it do not apply for design application. So very unfortunately, if you have a design idea and you turn it to invention, industrial design, you got to go with a normal non-provisional application. And provisional application is not exempt on the merit. We say in a fun way in the work office is that if you're not exempt, you don't pay for the examination fee, right? It cut you a lot of cost, but it's still safe, you're right. Provisional application for patent cannot claim benefit of any previously filed application. You guys consider it's the first step of the patent chain. So first step will be provisional, and then after that can be PCT, and then next it will be US application or other country national fee application. Right? So the last one I want to talk to you guys today about is become a patent agent, either in India or either in the US. I know out there have a lot of many resource and program, but be wise to the credited program because it's an impression in the eye of the recruiter and in the eye of your employer. Just imagine if you have a patent agent program certification come from somewhere called Youth Digital EDX Village, to say. It doesn't sound good like a intellectual property patent institute, thing like that. right? So be wise, and through your credited program, study for it, put in relentless, tireless effort, and then I'm sure that future will come true. Well, that I think 10 minutes is not long or not short, but that is what advice I can give today. It's a pleasure to be here.
Thank you. Thank you so much, Amy. And I truly love all your expressions and how you were expressing all your things. I simply love your energy. Over to Zish, ma'am, what are your comments on this? And especially she provides services in patent infringement funding and helping such companies. So what are your views on this?
Yeah, no, thank you so much. That was really, really interesting to hear. So, for example, in India, people can't, the patent agent exam hasn't happened. What are some other things that people can do to build up their skills?
Oh, I think that actually India is the third largest of IP registration in the world now. It ranked very equal to us. So I think you guys can get a lot, can study, can upgrade your skill from a lot of resource and program, and then don't mind go overbroad, and then join the patent training or webinar from either law firm in the US, either law firm in the UK, or either IPO office in other country. It will always have something we can learn from them, and then it will upgrade your skill. One of my colleagues in India, he said like this: he don't know, when he just started, he don't know about the prior art cert, right? He don't know about how to do the IDS. It's an information disclosure statement. We all know here, but young patent agent don't know yet. But I mean, the IDS is very important for the prosecution in every country. Well, he learned that actually through a webinar with a law firm in the US, and then he bring that skill back and then teach his colleague. Right, and then now all of his colleagues can do IDS. We are very sad about that because they no longer pay us to do IDS because they can do themselves, but it's good for them, right? Because they can do it themselves. So don't mind you. If you know how to search for the study resource, you can upgrade yourself in 1 year. 12 months is a lot. 12 months, all of young people or even patent agent and attorney, they can upgrade their skill if they know how to where to study the resource. I will leave a lot of a resource for Chester to share with people, because I know a lot of the link to webinar and to a lot of the credited law firm that they have a regular training program for free. So yeah, Chester will send that to people later.
Yeah. Thanks, Amy. It was such a grateful insight, and I can see a lot of thank you coming to you in the chat section from the audience for the great session.
Thank you.
Over to you, Sija. We have last speaker, Mercy, waiting. Let's introduce her for us.
Yes. Our last speaker of the day is Mercy Mutindi. She is an advocate at High Court of Kenya, specialized in technology, media, telecommunications, and health law and policy, a business strategies, a communicator, a public policy, government relations, and data protection manager. Also, she has worked for some of the most impactful companies and organizations across 10 African states, including Google, Microsoft, East African Community, DAI, WIOCC, SCACOMs, Safaricom, Diageo Group, Uber, amongst others, including various national government ministries. We welcome you now.
Thank you so much. So glad to be here. So I'll just be doing, I guess, a bit of an introduction or some insights for IP regulation in Kenya, simply because that is where I sit, even though my roles have spanned across various countries in Africa. But I'll just talk through Kenya for today to help represent my country. So I'm so happy to be here for IP regulation in Kenya. There's a lot of space for the youth to grow. Actually, a good number of the top lawyers in IP, there are quite a number of youths, like people below 35 who are really good, like IP practitioners in Kenya. I'd just like to give an overview of what the legal and policy environment looks like. IP is protected in our constitution, and it is recognized as a property right, in addition with, the other types of property. And we got our new constitution, okay, well, it's no longer new, but we got a repealed constitution in 2010. So since 2010, there's been a lot of advancements in as far as intellectual property is concerned, because it was now, recognized in the constitution, which was not the case previously. A lot of our IP is actually governed by the Industrial Property Act, which I will look into a bit later. We also have the Kenya Copyright Act. Then we have the Anti-Counterfeit Act. And Kenya is also a member of IIPTA. And we are also a contracting party to the Paris Convention on Protection of Industrial Property. In terms of most of the industrial property is managed by the Kenya Industrial Property Institution. There are a lot of opportunities here for the youth to engage, either as applicants to protect their intellectual property, or even in terms of jobs, as this is the main regulator, and they basically manage trademark, utility models, patents, industrial design, and also protection of traditional knowledge, which is quite a broad scope. Altogether. So for this one, in order to submit, there are opportunities for patent agents in Kenya. You can apply to be one. Most of the patent agents in the register are actually advocates, mainly because it's easier for advocates to apply to be a patent agent as long as they're admitted to the bar. It's assumed that they have been trained in intellectual property law. Intellectual property law is offered in law schools, but there are also quite a number of patent agents who have a scientific background. So in terms of training, so for the youth who have done any of the sciences courses, especially if they understand, inventions, manufacturing and such like things, that's also one of the viable career places and spaces. But then there are also a few patent drafting courses. We don't have that many. I actually only know, I think 3 universities or tertiary institutions that offer patent drafting courses. And yeah, so if you've taken a patent drafting course that is recognized by the Kenya Industrial Property Institute, you can apply, and there's an opportunity to be a patent agent. So most of the forms, whether for for applications, are available on their website. Before COVID, most of the applications and most of the processes were hard copy, so you literally had to go to the authority. But post-COVID, we're forced to all move online, even though the processes still rely on hard copy, filing of papers, and KIPI would still print applications that are submitted via email because they use physical files. But at least there was some level of improvement post-COVID in just welcoming some of the modern ways of working. We do have a lot of payments processed through mobile money. Mobile money is, quite a phenomenon in Africa and Kenya. It's obviously leading globally in terms of uptake of mobile money. So that is a big thing in terms of payments that are made, whether, payments that are being made to inventors, depending on, the different scopes of the payments that are allowable, but also payments for applications are also done through mobile money. Then the turnover time, we do have some challenges with turnover times, especially for the Industrial Property Institute, because first of all, the scope, they cover so many things all in one, and there's a shortage of examiners, there's a shortage of staff. Yeah, so there are opportunities for youth, like I think Amy just shared, like if you're able to do training and go into this field, like in Kenya, there's a lot of opportunity for that because there is a shortage of staff. And right now, like for example, a patent application, most of them on average have been taking between 2 years to 2.5 or even more just to go through the formal examination process from the, submitting the application to when you get a substantive response. The only advantage is that, if it's granted, then protection applies retrospectively. So from the date you submitted your application. But there is a really serious shortage of examiners. I think like last I checked, there were only, I think like 2, usually there are like about 2 active examiners, give or take, because we have shortages and there's some who are out in the field, out for further training, out on, official assignments and all of that. So it really slows down the process. For patents especially, but also trademark, the backlog is ridiculous. Then for KIPI, they also do have an outreach program. trying to just sensitize and raise public awareness for intellectual property. I think it's just, like some of the other speakers have mentioned, it's not really something that has been at the forefront of the way we've been doing life, particularly in Kenya for the longest time. And so there's just a lot of sensitization that's required to bring, and enable the public to understand, and especially with particular reference to protection of traditional knowledge. So yeah, Kenya being in Africa does have a lot of traditional knowledge, and there have been a lot of problems in terms of how do we protect traditional knowledge, especially within the context of modern IP law. Then the next main regulatory body for intellectual property here, we have KECOBO, that's the Kenya Copyright Board, and they mainly deal with copyright. There are a lot of opportunities again here for the youth to be able to participate, whether it's the creatives who will compose songs or computer code or anything that can be protected under copyright. So in Kenya, copyright subsists automatically to the creator, but should you wish to register your copyright for whatever reason, whether it's because you'll be engaging in sales or you need to undertake formal transactions where a certificate of registration would be beneficial, that can happen, and it's facilitated by KECOBO. Usually they have like a 7-day turnaround period, which is good. Everything is online, but then sometimes if the system is down or they have some challenges or delays, that may extend to about 2 weeks. But yeah, so for Kenya, we have had quite a bit of activity around our copyright laws, and that's mainly to do with safe harbor principles, limiting liability for intermediaries, especially the technology players and the technology companies. And then we've also had a lot around collective management organizations, particularly for the local music industry in Kenya, and how they manage royalty payments and collections. Yeah, so mostly managed through collective management organizations, which are regulated by KECOBO. Again, there's room here for youth to participate, either as creatives, as members of these collective management organizations. There are a lot of like employment opportunities within the same CMO framework for the collection management organizations. And there are also quite a few developments in Kenya especially for artists. The most popular, I think, method through which artists earn obviously is their performances, but then also there's ringback tunes are really popular in this side of the world, and the MNOs, the telcos usually pay the artists an amount of money, because subscribers pay to be able to have the ringback tunes, and that's partly where the collective management organizations come in to just make sure the proper payments are collated and paid out in times, quarterly, annually, or according to whatever framework it is that they have accepted. Then we also have the Anti-Counterfeit Authority, which is basically in charge of combating counterfeiting of goods, and this usually comes into play with pirated. I think there's a speaker who talked about piracy. I think it was Avi who mentioned piracy, and then also some level of consumer protection. Like, for example, we do have quite a number of cases of where, like, for example, counterfeits are sold with regards to especially alcohol. And beer and things like that. People will sell some brand of alcohol using the IP or bottles from another company. So there's quite some activity around that. And then in terms of legal reforms, we do have an intellectual property bill version from 2020 that has not yet gotten to, I guess, the end, or has not yet been passed by Parliament. It has sparked a lot of conversation, and industry sort of divided around it. Basically, the intellectual property bill proposes to just merge all the organizations into one. So that is merging the Kenya Kenya Industrial Property Institute, the Kenya Copyright Board, as well as the Anti-Counterfeit Authority all into one. And then sort of like, so you just have one super IP authority and then different directorates under them, also including a proposal for a directorate to manage, traditional knowledge, because that's one of the items that are emerging and hot and of interest for regulation in Kenya. We are also in an election period. So again, ideas around how to better manage traditional knowledge and things that endear voters is also currently in style. There also have been some amendments to the Copyright Act that were recently passed actually a month ago, just to be able to solidify the splitting of revenue between telcos, collective management organizations, and artists, again, partly to do with the election period and endearing voters. And there's just a lot of, a majority of the voters obviously are youth, and a majority of the local artists do fall within the youth bracket. And there have been quite a lot of controversies back and forth, court cases and fights around revenue share for the ringback tunes in particular. So yeah, that has been what has been keeping us busy. And I think I'll leave it there.
Awesome. That was a nice snapshot, and it was a great learning from your country. And thank you so much for the great insight, and from the whole community, we wish you a happy World Intellectual Property Day. And to conclude, from my end, I want to thank you all the speakers, and Sija ma'am and Zish ma'am, and all the support team, which has helped me to put this all the people together in one room and share the insights from their own countries. So thank you so much. And I must say it was a great successful event for us and for everybody. And I will move to Sija for a vote of thanks.
After this significant and interactive session, I would like to thank our guest speakers for becoming a vital part of this webinar. Thank you all for enlightening us with your words. In my opinion, the domain of intellectual property right is an emerging one, which will facilitate growth to each and every young individual creating any innovation and also creating a good scope of input. I would also like to thank Mrs. Cheshta Sharma and Mr. Kirtiman Sharma on behalf of my colleagues and the entire team of IIPTA for giving us the opportunity to learn and gain knowledge in domain of intellectual property. So audience, I would also like to mention to visit our website. It's www.iipta.com and take a precise knowledge. Thank you.
Thank you so much. And and for concluding the session, again, special thanks to Sija and Zish ma'am for supporting me for all these events, and thankful to all the speakers who, despite their different time zones, were able to manage and be with us today. And I wish you happy World Intellectual Property Day. This is Cheshta Sharma signing off. Thank you so much.